We are live. If we are not live, if somebody thinks we are not live, just tell me. But I think we are live. When we start officially, we will have 2 hours for everything. That will mean that the candidate will...
Yes? Sorry to interrupt you. Now we are live.
Okay. So welcome everybody. We are now live. Finally, I was doing a rehearsal of being live, but now we are live. The public should be there, and the members of the jury are almost all there. So we are now doing fine. This is the public defense of Giovanni, of Gianclaudio Malgieri, and about this subject, data subjects in the GDPR and the protection of vulnerable individuals. It's the first time we do these public defenses online at LSPS, and it takes some preparation. I still hear sort of echo of my voice, but I'm not supposed to talk a lot. I will soon give the floor to the candidate. The idea is that when we start, we have 2 hours for everything. This means Gianclaudio will talk for approximately 20 minutes. He will present orally the research that he submitted, and then we will give the floor to the members of the jury to ask questions. Are we still missing one member that should be there? I see that we are missing. In the meantime, we all look at this picture. And we about the candidate cannot say anything. You have to wait that I give you the floor. So it's about the vulnerable data subject and the general data protection regulation, and probably we need the members of the jury to be there. So I'm here basically just to reassure the public that you are in the right place. And I am in the right place, Gianclaudio is in the right place, but we are missing somebody. There will be time for questions also from the public. This is why this is called a public defense. So the candidate can answer any questions that the public may have. Still, I think it's better for the public to wait because maybe Gianclaudio will explain everything in the meantime. It's better to wait for the questions. I think at least one of the supervisors should be here. If we cannot get one supervisor, at least the other. I think it will be strange if we go ahead with no supervisor. It will not be. So I don't really hear any promising reactions.
We are trying to solve the technical issue with Frederik. I'm waiting for his feedback.
Okay, so I've been told we can actually start, and I think it's better for everybody that we start because we have this time limit, and we can try to be flexible with the counting. But still, it's better that we start. So we'll have 2 hours, I would say, starting from now to go through this. It is already sometimes a stressful moment for the candidate, and we don't want to make this too stressful because he might be suffering like the egg here with the hammer, even if there is no need to stress it. So I will just give you the floor, Gianclaudio, for 20 minutes to present the thesis. I think we will disappear and we will have the floor, and then we will come back and I will give the floor to the members of the jury. Please go ahead.
Thank you very much, Professor Gonzalèz Fuster, for this introduction. Thank you for all the members of the jury and to all participants. I I want to be resilient and not vulnerable in these sad COVID times, because I feel privileged to have participants all over Europe and even beyond Europe. So I feel particularly lucky in these unlucky days. So I'm going to talk about vulnerability, and in particular the notion of data subject in the GDPR, and how the vulnerability framework can inform the notion of data subject and how can be protecting more data subjects. You know, this aggressive image of a hammer and the egg can be discussed at the end. Maybe you will tell me who is the egg, who is the hammer, and who is the container. I hope that the data protection will put the hammer far and far from the egg. So basically, I think all the audience can use question and answer. And so if you like, I have a question for all the audience. Do you feel vulnerable? How many of you feel vulnerable people? And this is a question that maybe I will do also at the end of the presentation or of today. We will see how and whether you might change your view of vulnerability. So I start from I start from a gap, a problem, a definitional gap. We don't know who is the data subject. We don't know how many data subjects are there. There is just one average data subject or more data subjects, more categories. We know many stakeholders in GDPR are already defined, but for the data subjects, this unicity of the definition is still problematic because we have more and more individual differences in, for example, neuroscience is suggesting how different data subjects are and how the protection should be tailored to different data subjects. Some might suffer from algorithmic discrimination, like people belonging to racial minorities or elderly people suffering from the consequence of a digital divide, or children manipulation, or analysis of emotions on social media that might manipulate individuals. In my view, there is a need to protect individual data, to protect vulnerable data subjects. This compelling need comes first of all from the principle of dignity, which is a founding principle in the EU Charter of Fundamental Rights. But also, the Strasbourg case law in the last 30 years has been quite consistent in protecting different forms of vulnerable data subject in a wider and wider notion, and a layered and contextual notion where more and more people were included in this definition of vulnerability. But also, one of the founding rationales of EU data protection law was rebalancing power imbalance, and many national data protection law, like for example, even before the data protection directive, like the German or the Italian ones, have dignity as one founding rationale. Also, the mentioning of vulnerable people is actually in the GDPR, recital 75, but also indirectly in many other references, recital 43 about power imbalance, or the particular situation of the data subject in the right to object, or also the mentioning of children as vulnerable people in Article 6 or 12, and of course, an interpretation, an extensive interpretation, an analogical interpretation of children-related safeguards should be advisable. And also the European Data Protection Board and many authorities have been always consistent in mentioning vulnerable data subjects, but we still don't know who they are. So coming back to our definitional gap, we usually have this dualism between an average data subject and the vulnerable data subject, and we take these as a strong black and white dualism. Maybe we will criticize this view in a minute. So if we look in particular at the EU consumer law, the notion of average and vulnerable are quite solid in case law, legislation, and scholarly debate. But also in the data protection, actually, this is quite true. This notion of a reasonably rational, circumspect, and well-informed person. This notion is true also in the data protection. If we read the very first explanatory memorandum of the Data Protection Directive 1990, we find a rational data subject. But also if we look at the general safeguard, a data subject who is capable of reading data protection policies, providing consent, or exercising data protection rights is of course a reasonably rational or informed person. But this is totally unrealistic. Someone might say that this is anachronistic too. Indeed, the Court of Justice in the last year has been more lenient in affirming, for example, that it's not impossible that a user can ignore cookie policies. On the other hand, we usually see the vulnerable data subject as a person whose fundamental rights and freedoms are at higher risk. Well, the problem of this dualism that makes it an unsustainable dualism is that we usually tend to consider the average data subject as a white, middle-aged, intelligent, quite rich Western man, and the vulnerable data subject as an old, black, disabled, poor, possibly lesbian woman, and we see a great separation, like a barrier between the two. This black and white approach is inaccurate for several reasons. First of all, because there is a whole spectrum of differences from this white on black scenario to a more layered scenario. We don't have just the average and the vulnerable, we have several intermediate subjects, like a subject who is not as rational as the average one, if the average exists, or an intermediate data subject, or a mostly vulnerable person. But even this spectrum is inaccurate because it is bidimensional. We need a three-dimensionality. We need to consider the spectrum in different contexts. Our two stereotypical subjects can have different layers of vulnerability in different situations. For example, for sexually suggestive online ads, there might be a different positioning of the two vulnerable or average subjects, or for predictive policing, and so on and so forth. So we should still now understand what vulnerability means. I mean, in the first theories from political philosophy, law and economics, and also bioethics tend to see vulnerability under the particularism approach. So some people are vulnerable, but the problem is that this might lead to stigmatization. These people might feel twice vulnerable, once for being weak, and the other time for being part of a minority group. And of course, this makes a pathogenic vulnerability. That's why feminism in the last 10 years has been building this idea of universalism. Every human being is vulnerable. So vulnerability is inherent in humanity. But the problem of this approach is that there is a loss of significance then of the meaning, and also lack of specific protections. If everyone is protected as vulnerable, there are no specific protection for more vulnerable people. That's why the layered theory of Luna in the last 10 years has a quite relevant success. Everyone shares a minimum layer of vulnerability, but some people have more layers. And here the GDPR is very relevant because the risk-based approach and the layered approach of the GDPR might be very compatible with this layered theory. So in the GDPR, in the data protection, there are at least 3 factors to be considered for vulnerability. We usually think at the same, we always spontaneously think at data subject characteristics, being of a certain age, being of a certain social minority group, being of a particular sexual orientation, etc. But data processing is relational. So vulnerability comes from an encounter from some data subject characteristics and some data controllers' potentialities. In particular, I'm referring to computational capabilities of the data controller, or the amount of information, predictive analytics power, etc. And the third element might be very relevant, vulnerability drivers. So some acts who are maliciously planned by the data controller to exploit the characteristics of the data subject. Well, in the data protection, there might be 2 types of vulnerability, 2 manifestations, different manifestations, during the data processing or after, or as an outcome of the data processing. During the data processing is what I call processing-based vulnerability, the difficulty to understand rights, risks, implication, and significance of a data processing. The difficulty to give consent, a valid and free consent, or to exercise data protection rights. And this is typical of children, of course, elderly people, digital divide, but also workers. An employee might feel unable to deny consent to the employer data controller. The affect-based vulnerability is generally the easier form of vulnerability that we can imagine. A data processing leads to some effect at the end: discrimination, manipulation, limitation to freedom of movement, and so on and so forth. Trying to summarize these 2 different manifestations of vulnerability. The fundamental rights at risk are different because in the processing-based vulnerability, the problem is loss of control of data, so privacy and data protection, while in affect-based vulnerability, all other fundamental rights are at issue, like freedom of thought, non-discrimination, etc. And then if we analyze under the three layered, the three factors of vulnerability that I mentioned some slides ago, these are all different for these two different kinds of vulnerability. The characteristics of the data subjects, which are more relevant for processing-based vulnerability, is the incapability to read information, for example, or the linguistic issues or cognitive issues, and so on and so forth. While in second case, so for affect-based vulnerability, it's, for example, being part of a social minority group or being physically or mentally weak. And so it happens the same for data controllers' potentialities. It's an imbalance, but with different effects. So hierarchical or institutional informational dominance from one side, or augmentation information asymmetry for affect-based vulnerability. Examples can be many, children in many contexts and situations, because children are both vulnerable to read privacy policies or give consent, but at the same time they might also be more susceptible or vulnerable to some manipulation, commercial manipulation, for example. Or also consumers. There might be consumers that in a certain hour of the day or in a certain period of the year, in a lockdown situation, for example, they might be particularly vulnerable to aggressive commercial practices. But then if everyone is vulnerable, where does the law take place? Where do we put the vulnerability threshold? Well, we put the threshold at high severity and likelihood of impact, but also fundamental right or freedom. So there should be an impact on a specific fundamental right or freedom, of course, like freedom of thought, freedom of non-discrimination, data protection, privacy, and so on. So what is also important is the risk, so severity and likelihood of the impact of these fundamental rights and freedom. Severity and likelihood are quite difficult to be analyzed. We use the data protection. I use the data protection impact assessment model to analyze this varying risk because it's the best data protection risk assessment model that we probably have. But the notion of severity is very particular. How can we legally define severity? Well, in the thesis, I tried to analyze and to measure vulnerability threshold on the severity of effects in the GDPR, looking in particular at the different mentioning of effects that we have, from mere effects to damages. It's an increasing level of severity, and they are concentric. Every layer, so every kind of effects mentioned in the GDPR, might include the following layer, or might be a specification of the previous layer. Well, this difference, so this concentric scenario might lead to analyze one-to-one. So mere effects, of course, is just the definition of personal data related to a data subject. So this relation can be defined under the effect perspective. It's not enough to trigger vulnerability, because our question here is the risk of which effects make me more vulnerable. Then substantial effects, an underestimated notion in the definitional Article 4, for example, for the competent data protection authority. In this case, the substantial effects might be a vague and very wide and diverse gathering of effects, which is not appropriate for our purposes. Significant effects was in the automated decision-making provision in the directive. Now we have a new form of effect, legal or similarly significant effect. This reference to similarly seems particularly relevant for us, and it's more foreseeable. Legal or similarly significant effect are some nuisance to fundamental rights without any need to reach damages, which are some losses, quantifiable losses that can lead to a right to restoration. Well, so if we put all these effects on the spectrum, I think that the borderline can be legal or similarly significant effect, the borderline of vulnerability, because the European Data Protection Board often gives example of legal or similarly significant effects as discrimination, manipulation, and so on, that are all examples very relevant for our framework. But also the GDPR mentioned legal or similarly significant effect in most sensitive scenarios as a real benchmark for sensitive scenarios, Article 22 about automated decisions or Article 35 in high risk data processing. So from this point up, considering also likelihood, there should be some legally relevant vulnerability. So the data controller should implement some safeguards. Well, so trying to reformulate definition, the borderline of legally relevant vulnerability, so the new definition of vulnerability that we can give is the higher likelihood of suffering from legal or similarly significant effects on one's fundamental rights and freedom in a specific context and relation. But the question now is the GDPR adequate? Is really the GDPR as it's written today an adequate tool for protecting vulnerable people, to mitigate vulnerability? Well, in my view, yes. If we look at principles, for example, lawfulness principle requires assessing the vulnerability level of data subject, because we need to understand the data controller that want to implement, for example, to use consent as a legal basis. She needs to know whether the data subject is able to provide valid consent. In case of legitimate interest, she needs to do a balancing test where also the effect of data processing are analyzed. On the other hand, sensitive data protection is also something very relevant for vulnerability. And just a parenthesis, of course, anti-discrimination law is something that is just complementary to this approach, but is not substituted. Fairness has several nuances. Procedural, fair balancing, preventing discrimination, or good faith, but they seem to all refer to significant imbalances, so to rebalance this imbalance between the controller and the subject. Transparency also, critical transparency tends to rebalance the informational imbalance. Accuracy, because accuracy might help to avoid discriminatory biases, but at the same time to prevent so if the data controller knows better and more accurate information about vulnerability aspects of the data subject, the data controller can put in place some adequate safeguards for the subject. Rights, so the right to access, which is like just implementation of transparency, to right to erasure, that also rebalances and avoids the continuation of adverse effects of some data processing on the vulnerable data subject. Right to object, which for me is the most important one, because it refers to the particular situation of the data subject. And many countries, like for example Ireland, define this particular situation as the higher risk of damage, which is actually our definition of vulnerability too. And of course, right to object might be a way to block the data processing in several scenarios. So to block the data processing where consent was not used is the corresponding right to withdrawal of consent, and it should be made easier and easier for vulnerable subjects. Automated decision making, not only because it's used the benchmark of legal or similarly significant effect, but also because the result, for example, the preamble of the GDPR refers to limit this aggressive practice, or if it's at high risk for children. All safeguards should be proportional to the layer of risk, and we can imagine more explanation or algorithmic impact assessment. Accountability duties are extremely important too. In my view, the risk-based approach is exactly compatible with the layer assessment of vulnerability, so a gradual and contextual assessment. But at the same time, the data protection by design, the data controller does not need only to protect, to be compliant with the GDPR, but to implement the principles in a proactive way. And that's why I think that the vulnerability framework is totally compatible with the letter of the GDPR. And the data protection impact assessment, as I was saying, is for sure the best way to assess vulnerability layer and also propose mitigation measures. Of course, there are many possible remarks to this scenario. The first is individualism. So if we consider just a case-by-case approach, there might be the risk to lose contact with reality, because we know that vulnerability is a structural problem. And structural problems should be faced by groups, maybe. Well, in my view, there is also the risk that groups can stigmatize individuals. So more contextual, more homogeneous subgroups that I call layers can be considered. A homogeneous characteristic of the data controller, homogeneous characteristic of the data subject, and a homogeneous vulnerability mechanism. We might have some layers that are relevant in several cases. We need approximation. We cannot go just for individual vulnerability. Foreseeability is another issue. How can the data controller know from the outset whether and which kind of vulnerable data subjects will be in the data processing. Well, the data controller might do a self-assessment test, for example, wondering whether whether vulnerable subjects are specifically addressed in the data processing, where vulnerabilities are exploited, like in particular information, or where a huge amount of information is at stake, so that the data controller potentiality is very, very meaningful. Legal interpretation is also an issue. We are creating this story building on some GDPR provisions that are not referring explicitly to vulnerable people. And the mentioning to children, can we really use such an extensive analogy for children? Well, in my view, the GDPR with the risk-based approach and the accountability mechanism already encourage to adopt vulnerability-tailored safeguards. Issue overestimation, the cat that believes to be a lion. So we are creating a whole story, a whole PhD out of a recital, out of a sentence in recital 75. But actually, in my view, as I was saying, it's not just there. It's implicit in many parts of the GDPR, the protection of more vulnerable people. As I was saying, Article 21, 6, 12, Recital 43. But it's not just that. It's that the protecting vulnerable subject is a fundamental right-based necessity. Paternalism also is an issue, because we could limit the autonomy of individuals if we said that someone is not able to give consent. But actually, protecting the decision-making is not cancelling the decision-making, and there are also collective interests at stake. So the last question is whether the GDPR is enough or we need something more. As I showed, the GDPR is already adequate, but a more explicit recognition could help. How? We have two possible models. The general approach, which is suggested by the Unfair Commercial Practice Directive model. There is an open-close definition of vulnerability and maybe some examples, some blacklist from Data Protection Authority, etc. Or a category-based approach, which comes from examples, for example, from the clinical trials regulation model. There are some specific provisions for every different vulnerable kind of vulnerability, like one article for the elderly, one article for the children, etc. But in my view, just the first approach is more adequate to deal with this issue, because it refers to a more specific, layered and contextual approach, and also more durable. So thank you very much for your attention, and I'm very happy to reply to any question that you might have. Thank you.
Thank you very much, Gianclaudio, for this presentation. I hear noises. We are limited in time, so I will just give the floor directly to the first member of the jury who's going to start the discussion. And we have agreed on an order, and the first member of the jury to have the opportunity to talk with you is Orla. Lynskey is Associate Professor at London School of Economics and Political Science. And we are very happy that she's with us for this discussion. But I would like to give you the floor, Orla, please go on.
Many thanks, Gloria, and thank you, Gianclaudio, for the presentation. And so let me begin maybe by, first of all, congratulating you on what I thought was a really excellent piece of research. And as I think will be obvious from your presentation, what was I think very enjoyable about this PhD is that it works on what is a legitimate gap in the existing literature. So we see here that on the issue of the data subject, and in particular the vulnerable data subject, there is a real doctrinal gap, and you've sought to occupy that space in a very original way. So first of all, congratulations.
Thank you.
I'm going to start off with some easy questions, I think, for you to get the ball rolling. But in thinking about the PhD and reading the PhD, it is quite a technical piece of work. And so in reading, I was wondering how it links back to some of the bigger debates that we are seeing at the moment in data protection law. And so I think one first question would be, how does your research link to the concept of fairness? And if I might just kind of elaborate a little bit. In the PhD, you kind of conceptualize fairness two different ways. So first of all, you state that fairness could be something that goes beyond a legally enforceable principle. So I guess that's kind of a more ethical vision of fairness, perhaps. But it seems to be an alternative vision that you propose is that fairness could be used to enhance or to bolster the interpretation of existing data protection principles. And on that second interpretation, that sounds very like what you just described the role of vulnerability to be. Because you just said that GDPR can be vulnerability aware. In so vulnerability itself can be invoked to add an extra dimension of interpretation to existing principles. So then how do we distinguish between fairness and vulnerability? And can the principle of fairness simply be invoked in concepts or in contexts of vulnerability? Or does fairness have a role that goes beyond vulnerability?
Yeah. Okay. Thank you so much, Professor Lynskey, for your interesting questions and for all your comments. I think that, yeah, the bigger debate is very much important. The bigger debate about fairness is, of course, a very open issue, I think. We had a lot of literature, now we have more literature on the point, but still the very core of fairness is maybe for its nature quite impossible to catch. I accepted very well your comments about legality in the private defense. I think that it's inappropriate to say that fairness is just beyond legality. Fairness is within legality, but fairness is contextual and beyond lawfulness. So in my view, fairness is beyond mere abstractness. Fairness is very much case by case based. And still, so what's the role? So if we can distinguish fairness from a vulnerability approach, so whether fairness is actually considerable as something more than rebalancing vulnerability or not. Well, in my opinion, vulnerability is an extremely layered notion, and we are all extremely, I'm repeating myself, but just for putting some clear points at the end. So we all share some minimum layer of vulnerability. And this means that, of course, fairness can help, is always dealing with vulnerability. Because when there is an imbalance, the data subject is always in a vulnerable position. But in my view, at certain level, at certain layers, the vulnerability is unsustainable. And the data controller should act to reduce such form of vulnerability. We can call it high-risk situations and high-risk data protection. So fairness, in my view, has both an ex-ante role in preventing that this vulnerability go to such a high-risk level. So preventing that exploiting the vulnerability that we all have as data subjects can go up to an unbearable level. And at the same time can be a backstop tool. So as blocking existing scenarios that are considerable, like exaggeration or exploitation of vulnerabilities. As an ex-post tool, I think that data protection authorities should act. They should give clear examples of what is unfair. We have several ways to codify better vulnerability, but to codify better fairness. But I think that maybe we can learn from Unfair Commercial Practice Directive, where we have a list of unfair. Of course, it's a soft law list. It's incomplete, but at least to give some ideas to the data subject of this unfair situation. And in my opinion, this unfair situation have a vulnerable data subject at issue. So yes, we might say that there is a big overlap, but up to a certain level, the fairness stops being a preventive scenario and starts being an ex post tool. And I hope I answered to your question. So.
Yeah, that's great. Thanks. I'll need to think about that a little bit more. But if I might just ask a second follow-on question then. So in the PhD itself, you start off, as you did in your presentation, with a very kind of dignity-based vision of data protection and the data protection framework. And then at some point you kind of jettison this kind of human rights approach because you indicate that damages or interferences with fundamental rights are very difficult to measure, and this makes them tough to use as a benchmark in essence. And therefore you opt for the approach that we've heard about today, so that kind of more layered risk-based approach. And so again, I'm just wondering if you could explain to us the relationship then between this layered risk approach, which seems to be a very kind of compliance-based approach, and the human rights context in which it sits.
Yeah. Yeah, again, thank you very much, Professor Lynskey. I think that this is a very crucial point in the bigger picture, because the bigger picture is dominated by the debate between the risk-based approach scholars and the right-based approach scholar. Maybe it's very easy to say, but I tend to be for a third way. I kind of disagree with this strong division between right-based and risk-based approach. Why? I think that rights, fundamental rights and level of severity and likelihood should be read in conjunction as much as possible. The human rights approach is, of course, based on interference with fundamental rights. So if data protection can interference with fundamental rights, then of course there should be a relevant legal reaction. In my view, the level of interference is of certain entity. So at certain level, we might have in principle an interference with the fundamental right that is not clearly requiring some reactions. So some interference that is acceptable and tolerable. But how can we define what is acceptable and tolerable? In my view, understanding and assessing the severity and likelihood of this impact. So in my view, the two tools should be somehow read together. It's not easy to do in legal terms, because we are trying to put a risk-based scenario, let's say a risk assessment scenario, which is a law and economics perspective, in something that is purely human rights. So I mean, extremely abstract and how to say concrete, but still based on strong concepts. I think that these two concepts should be read in conjunction in a way that every effect should be clearly relatable to a fundamental right, but at the same time we should assess the threshold of severity, because the risk of considering just human rights without any severity might turn to say that we are everyone vulnerable, and so it's the universalist approach according to which there's no need of specific protections. But if there's no need of specific protection, the effect is the one that I try to put in the picture, so that we are all trying to look at the match, but it's not possible because we have different we are told in different way. So I hope this replied to your question.
It does. Thank you. I'm going to pass the floor to colleagues now. Thank you.
Thank you very much.
Thank you very much, Gianclaudio. When somebody is asking a question, maybe you could mute yourself, because otherwise we hear a strange echo and we cannot really.
Oh, sorry,
Gloria, you are muted.
Yeah, you muted. Okay.
I'm muted now. Can you hear me now?
Yeah.
Okay. So I said, Gianclaudio, can you mute yourself when we talk, but not mute me? Professor Giovanni Comandé from Pisa in Italy, but not now in Pisa, but that doesn't matter that much. Please have the floor.
Thank you, Gloria. I will try to be as fast as possible. And to do that, we had already a discussion a few weeks ago where I asked you many questions and you very well answered. So let me just very briefly say how much I appreciated your thesis. I think you transformed the PhD writing into a challenging business because you put yourself a very large number of challenges, methodological ones. You have been using comparative tools, opening to empirical research, although you didn't have the time to run empirical research, and to interdisciplinarity. And you embarked potentially in all branches of private law because your subject touches upon labor law, consumer discrimination law, and so on and so forth. The final layer, using your language, the user and the challenges, is that you run a micro and micro analysis. So broader picture and focusing, zooming in. Now, all these challenges that you have been battling with very well, I must say, lead to potentially a very radical critique. You've been talking very well. Actually, the presentation was excellent, as your presentation usually are, about vulnerability, different layers, different boundaries. But now, don't you see, and actually you claim that risk in your thesis, so you do see it, that such an approach to vulnerabilities might be leading to a todos caballeros, to basically transform everybody into a potentially vulnerable data subjects at certain levels, which is partially even true, in the reality of the data economy, and you analyze this aspect. Now, to move further in your research, how would you envisage, a sort of a practical test? And you laid down the boundaries for it, but how would you, for instance, for a company, a practical test and a workable notion of vulnerability that enable the boundaries you described in your presentation to avoid the todos caballeros, that everybody is to a certain degree vulnerable, and where you put the thresholds you have been mentioned. Since you don't have the time to answer such a broad question, maybe you might want to share, but that's your choice. How would you put in practice the severity and likelihood test? How would, in practical way, perform? That would be an option, but it's up to you.
Thank you very much, Professor Comandé, for your input. I think this is also a very crucial point, because it's also the practical implications of my research. I think that, the risk of a layered approach, as I was saying in some slides, is that everyone goes in the big gathering of vulnerable people, and so the universalist approach, again, as I was saying to Professor Lynskey before. In my view, it's clearly, we really, and actually this point is a perfect continuation of the discussion that I was having with Professor Lynskey, because actually I think that the point of severity and likelihood are the real distinguishing characteristics. So if we use the existing risk assessment models that we already might have for different fields, for example, ENISA, so the cybersecurity European entity, has already providing some different forms of risk assessment for different kinds of severity and likelihood of risks in different scenarios. Or we might have other existing examples. There's always a layer of effects from, and layers of severity and likelihood, from the very negligible effect, the medium effect, the high medium effect, and the very severe effect. In my view, the data controller should put the threshold where the effect goes up to the medium. So from the high severity of effect, we are already in a vulnerable situation. That's why for me, the real benchmark is understanding what legally or similarly significant means, because as I was showing in the presentation, this is a clear notion that puts the borderline between what is at high risk of severity, high severity, or non-high severity. So in my opinion, for every kind of different scenarios, we can imagine this, having always clearly in mind that there might be an intensity in the effect, but also a different perception of the offense. And these two tools should be read together. Always fundamental rights at issue, but for every fundamental right, we should look at the existing implication. So, of course, as you were saying, I had no space in my thesis to give all possible examples of high risk in all scenarios, but I was very happy after the private defense to mention, and so to add mentioning, for example, of the cybersecurity scenario, where there are clear examples of what is up to the high risk. For example, it's like embarrassment that can lead to psychological issues from a cybersecurity attack or economic loss, and all these kind of secondary effects that are clear index of the severity of the impact with the fundamental right at issue, that in that case was data protection and privacy also. I hope I replied to your question.
Yes, you did, and you kindly allowed me another couple of minutes. So the flip picture of this question and your answer is that maybe, I mean, to work out a workable notion of vulnerability, we might need to concentrate not on vulnerability, but on defining power. In one of the samples you mentioned in your thesis, the ludopathic, which is a target of loans, and which is the example given by the board, the data protection board, right? There, I mean, there is no fundamental rights at stake, if you want. There is no big power either, but for this little information that you are a ludopathic. So the proposal of loan make you more prone. So what do you think? I mean, how would you define then the imbalance of power that you talk about all throughout the thesis, and how it would impact the notion of vulnerability? So we might be vulnerable just because the other part is more powerful, and the powerfulness could be really the micro one, like this one.
Yeah. Thank you again, Professor Comandé, for this further input. Yes, I think that this is a very clear example also for the audience, for example. I think, yes, of course, the ludopathic and the bank. Okay, these are the two. The data subject is the ludopathic and the bank is the data controller. Well, in my view, we should analyze, as I was saying, the three determining factors of vulnerability: data subject's characteristics, data controller's characteristics, and eventual malicious mechanisms that are at stake from the data controller to the data subject. I'm not saying that for each of these three layers we have to have a clear high evidence. What is important is the relation between these different layers, the different factors, turns as a vulnerable situation at the end. In particular, if I am ludopathic, I'm not vulnerable for what concerns relationship with, I don't know, public administration, or it depends, but or with, I don't know, my family might be, but still different levels, different context. I am vulnerable as a ludopathic towards someone that has power to make me feel tempted to play, tempted to bet, tempted to earn more money, etc., etc. So the ludopathic and the bank are already in two very particular relational vulnerabilities. So I mean, there is a relational vulnerability between the ludopathic and the bank. So it does not need to have such a huge power. It's just one small notion that is relevant at this moment. So just added to the different positions at stake that could lead, in my view, to high level of vulnerability. So actually, there are some inherent forms of vulnerability in some encounters. That's why I was talking about encounters of vulnerability, because in my view here it's clearly an example of these two different characteristics and some vulnerability drivers in between. I don't know if I clearly replied to your provocation.
Yes, you did very well. Thank you.
Thank you.
Thank you both. So if Professor Comandé is satisfied with the answer, we will move to our next member of the jury, and this is a local member, I would say, but not less important. So Professor Gutwirth from VUB, please have the floor.
Yes, Giancarlo, I'm happy to see you. I wasn't there at your private defense, but I heard it went very well, and it doesn't surprise me because me too, I have very much appreciated your work, and I rejoin the compliments that have been made by the other jury members. I was impressed by your work. I also like your commitment for yes, in order for protection or better protection of people with vulnerabilities. So I share your concerns, and I think you made an excellent work. Indeed, my task is here not only to give compliments, but also to ask some questions. And my first question will pertain to data protection and privacy. Your thesis is about vulnerability and data protection, and I think that maybe data protection is not the best field of law to protect vulnerable persons, and certainly in the relationship between privacy and data protection, which are made or which are conceived in a completely different way. The one is more administrative law, the other is more prohibitive. I was wondering if we shouldn't turn more to privacy, because privacy, I think, is the fundamental right that protects individuals against disproportionate steering of their conduct. And actually, privacy, in my opinion, should exist to resist all forms of nudging, of the steering of conduct. And I'm rejoining a little bit what Professor Comandé said about power relationships. In Foucauldian terms, power is, in French it is said, la conduite des conduites, so the steering of conduct, and privacy actually became the residual fundamental right that protects individuals against the exercise of such power by public authorities or private persons, if such power is disproportionate in terms of human rights law. Now, I am wondering if there doesn't remain a very important role for privacy to play, especially with regards to vulnerable persons, against such disproportionate exercise of power through data processing, because and as a consequence, we could maybe, when vulnerable persons are at stake, try to engage privacy claims against situations that were legitimized by data protection. So maybe as a first step, this issue I submit to your comments. Microphone.
Yeah, sorry. Okay, thank you very much, Professor Gutwirth, for all your comments and inputs. This is a very like also basic point, the conflict or the dialogue between privacy and data protection, and where do we put vulnerability? And actually, in the lack of literature on this point, actually, as you are right in saying that vulnerability was usually associated to privacy and not so much to data protection, both in Europe and in the United States. It's a common, usually vulnerability is considered as mitigated by more privacy. And also I appreciate a lot reference to, I mean, I agree of Foucault and the structural balancing of power, which I think is the best way to look at the picture today, not a one-to-one power, not affect-based power, but it's more structural problems. So I think actually, but if we do a step back, going to what you were saying as privacy is more prohibitive and data protection is more administrative based, well, I think that both elements are necessary in this scenario. Of course, privacy, and also in my thesis, as I propose some safeguards, I tend to be sometimes more prohibitive than just administrative, we can say. I think that in some forms, the GDPR might lead to a better protection of privacy as a prohibitive element. For example, when consent is excluded for some vulnerable people, not explicitly but implicitly, when we have, for example, also the fairness principle, as I was saying before, that might be seen sometimes as a backstop scenario, or lawfulness also. I think that privacy is, of course, very relevant, but I was describing also another manifestation of vulnerability, which is the manifestation of vulnerability within the data processing. So, for example, losing awareness of the data processing at issue. So I think that the complementary approach from a data protection might help. An administrative approach might help in giving some affirmative actions. In my view, affirmative actions should go with joined and combined with prohibitive actions. Some affirmative actions are, for example, the impact assessment. The impact assessment and the mitigation measures at the end, but also, for example, imagining critical transparency, as you and Paul Vert's famous paper, Transparency versus Opacity. I think that we need transparency also to rebalance vulnerability. It's not just the protection of my life, I also want to be more actively protected in my relationship, which is of course also under the scope of privacy, but data protection gives us some clearly usable tools to rebalance and to gain more, for example, as I was saying, critical transparency and automated decision-making safeguards, for example. So yes, I think that the two tools should be read in conjunction. I hope I replied your question.
Yes, absolutely. Yes, I still have my micro up. No, absolutely. This is a very good answer. But I still have a supplementary question linked to what you've said. What we see in data protection, with all the procedures it has invented, the DPIAs, the control commissions, the administrative procedures. They have the tendency to leave out the judge. So quite some data protection issues never end up with a judge, while a privacy issue is doomed to end up with a judge, because there are not all these intermediary procedures which have been invented by data protection. And I wonder, and I know that this is open for discussion, and I know that Gloria disagrees, which is a good thing. But wouldn't the judge be the best placed person to be able to take a decision which recognizes a vulnerability in a situation, because all vulnerabilities are also situational. They are never only structural. They are never only categorical. And this is also what you say when you draw this large image of vulnerabilities. But at the individual level, there is always also differences. And so I wonder if the judge is not a better, even more reliable person than all the instances that have been created by data protection to protect vulnerable persons in a certain situation. But this is an invitation to reflection more than the request of an answer, indeed.
Yes, thank you very much, Professor Gutwirth, for this further development. I think that the role of the judge in data protection is very particular. This is an opportunity also, in my view, to assess the role of the data protection authority. Can we consider them as judges or not? And so it's I'm very glad to remind the work that I did at the first year with Professor Hert about the notion of data protection authority in different member states, if they have the same guarantees of judge, if they have the same mindset of judges, if they have similar safeguards, protections, etc. I think that actually, of course, as you were saying, it's a $1 billion question, so it's not to reply immediately. But I think that some hints in the GDPR might be also used for, of course, for courts, in particular representative of the data subject at Article 80. I think that we should give much more importance to the representation of data subject, which is not just in data protection authorities trials, but also in courts. And this notion of the representative of the data subject, in my view, for groups of vulnerable people is relevant. For layers, for homogeneous layers of vulnerable people, there might be a relevance for this representation of data subject also in courts. And but for one thing, I think that, for example, for fairness principle, I'm not sure whether it's better that the judge decides or whether the data protection authority. I mean, data protection authority, of course, has a more data protection focused analysis, and maybe as I tried to show in a part of one chapter, the fairness principle should be read in conjunction with other fields of law, and so the judge maybe might have a better knowledge of fairness in contractual law, intellectual property, and so on and so forth, so in the competition, etc. So yes, but I mean, I would, as I was saying, and to the first reply to Professor Lynskey, I would not strengthen the dualism, but build a bridge between the fields. I hope I replied to the question.
Yeah, thank you very much.
Thank you very much.
Thank you all. I'm not sure I disagree with anybody, but I will not discuss this now. I will directly give the floor to the next member of the jury. He's a local and a non-local. He's with us and with the University of Amsterdam. Joris from Hoboken, please have.
Thank you very much, and thank you, Gianclaudio, for your presentation and the interaction so far. I've very much enjoyed reading your thesis earlier, and the private defense, the exchange that we had there. And I want to compliment you again on your work. Also want to compliment you on some of the revisions that you send us. I think this shows how much like an eager researcher you are. You're very insightful and inspiring, I think, in the way you work, and so it's been a real pleasure to have you at the department, to be able to be a colleague of you at the department. I think you're also, I would say, and the thesis, I think, is a good example of that, is be very goal oriented. You know, like you want to make this contribution. You're interested, and you got very interested in this particular concept of vulnerability, and you're not just reflecting on this, but you're really trying to move forward to see how you can operationalize that and to make it practical in the legal world. So my compliments for that. The question that I have for you is a question that I also somewhat asked earlier, but you, from like the revisions that you sent, I saw that you did a bit of more work for that, and I just want to maybe broaden the question also a little bit. So the question is in relation to the principles that you selected to engage, you know, this question of like what kind of work can the vulnerability concept do in the data protection framework. And well, some of those principles have been discussed, and you know, and a principle for me that stands out as very interesting is the information quality principle, the information accuracy principle, as you could also call it. And the reason for that is that I think that also lays bare a certain tension that is inherent within the data protection framework. We know of, like, I mean, there's quite some work to show that there are some inherent tensions, you know, in data protection law, and I think this doing this work on like letting your kind of light shine of how vulnerability would play out in respect to information quality or accuracy shows some of that tension, and your thesis already got to some of that, and I think now with the revisions you make some more points of that. So very kind of high level, the problem can be, I think, that on the one hand we have under data protection law we have a right, you know, like that is protecting people against, you know, over collection of data, and it's like a certain kind of confidentiality interest, certain amount of, you know, like information remaining confidential, not being processed, not becoming accessible to certain entities. And then on the other hand, I think we have a fair amount of principles, and in particular now, you know, in the world of predictive analytics and, you know, a world where data collection is pervasive, you know, we maybe see more and more emphasis, and also we see how much data protection is also about, let's say, the fair data-driven treatment of people and communities. And I think when you start looking at the information quality principle from the vulnerability concept, you start seeing that tension. It's like on the one hand, you know, like you say, well, you know, it's actually there should not be incorrect data, and incorrect data should be deleted, and it could, but then on the other hand, you know, we have this fair data-driven treatment, and maybe to treat people fairly, you need good data. You know, if once you go this route of treating people on the basis of data, you know, on the basis of what you know about people. And so I'm very curious about this tension. I've written a bit about that myself. And so my question for you is this: you have done some work on this now, and some thinking of this now also in the summer. And I'm just curious whether you think there's any possibility that you could use the vulnerability concept to resolve some of this tension. Because it's quite a dilemma. We see it also in non-discrimination discussions, you know, like to prevent discriminating, we maybe need to collect a bunch of sensitive attributes, and then we can prevent that we discriminate, to treat people unfairly, otherwise, you know, we do not know, and maybe there's a proxy. And so, and I don't think we're getting very far in that discussion until now, and I'm just curious whether you feel that, whether you think that there's a chance that using your theory on vulnerability would be able to move beyond some of those discussions that are somewhat in a deadlock. That's my question. Thank you very much.
Thank you very much, Professor van Hoboken, for your compliments and questions. I'm very happy to talk about information quality and accuracy, because I think that of course there is also vivid conflict in this. I mean, as you were rightly saying, we are trying to do data minimization, so why we should work on data accuracy. And again, this is a wonderful fil rouge with questions of Professor Gutwirth about the relationship between privacy and data protection. For sure, accuracy is not privacy, it's just data protection. So the accuracy principle has this ambiguous role. And also it relates to the point of algorithmic discrimination that you were saying. Like 12 years ago, computer scientists were already wondering about whether we should eliminate the sensitive data from at all. So for example, black people, we don't put the color of the skin, or we should use it to reinforce the protection of these people as an affirmative action. So more sensitive data or less sensitive data to protect the vulnerable, more accurate data or more shaded data, like more faded data. No? This is also an issue. And so I think I tried to reflect upon this because, of course, it was very tricky. I think that we should, so we can agree on a minimum level that if the data controller processes some data about vulnerability of individuals, this data should not be inaccurate when the data controller is complying with the GDPR. So, for example, the data controller, in my view, once that the data controller knows that some data subjects are children, it's good to have also the information about the age of the children in order to understand how better tailor the information principle, so the transparency principle, so to give more accurate information or more accurate data. This doesn't mean that the data controller should over-process, over-collect data, but just that if he or she is already processing some data related to some vulnerability, it's important that this information is as accurate as possible, unless the benchmark is the lower. So we give it for granted that the younger child is at stake, but still this is an over-protecting approach that might be very problematic under the autonomy principle, etc. So yeah, I totally see this this conflict and this ambiguity. I think that in particular Article 11 might help under a not a literal interpretation, but under a ratio-based interpretation. So Article 11 says that we shouldn't collect more data to protect better the children. Actually, we shouldn't collect more data just for identifying the data subject. I'm very simplifying here. I think that we could apply it also to the accuracy principle. So we shouldn't collect more data to better protect the children, the vulnerable person. But once the data controller already processes such vulnerability information, then I think it's good to have accurate information in order to be able to protect adequately them. It's true that if I know a false information of a subject, maybe I will not be biased again some vulnerability of that subject. So if I know that a person is Western and not Eastern, maybe this might be helpful. But in my view, in this case, and again, privacy versus data protection, we should go for accuracy, but also proactive protection ex post. Not easy to be done by lawyers, but I think that at least we could inform the discussion in this way. At least this is my perspective. I hope I replied to your question. Your mic is muted.
I don't. Do I have time for a quick follow-up?
Yes.
So I am quite satisfied with some of your responses. I think a lot of more can be said about it. Like, I'm just curious, you know, like whether you could take the information quality principle also in another direction. I mean, I think it's a fairly convincing argument to say, you know, like if we decide how to treat people on the basis of data, you need a lot of data, you know, like to do that well. I mean, that's just kind of how it works. But I think there are quite some, what I would say, vulnerable groups like marginalized communities that have very little faith that information quality or algorithmic quality is achievable with respect to their communities. And So they are taking a different position. They are actually saying we don't want this data to be collected at all. And I mean, you could say that is actually a different principle that is at work there. Used like that's more like a real privacy right or right to be let alone, you know, like, hey, just we don't want any interference. But the concerns there are very related to information quality as well. Just like you're not going to get very good information on our communities, and then, you know, then ending up with a certain claim that's much more a refusal to cooperate to give more of that information. Do you think that's a possibility to take also on the basis of that principle, or is it not, or do you not find that convincing?
Yeah, thank you again, Professor, for this development. I think that we can build maybe on the dualism in manifestation of vulnerability that I tried to draw in my thesis, processing-based and effect-based. I think that in processing-based vulnerability, the accuracy of information, so the quality of information might be more relevant, because in that case, I really need to know whether my data subject can understand or act properly. In that case, the accuracy might be helpful because the proactive actions are more relevant. While in the other case, in effect-based vulnerability, which is more relevant to the point that you were raising, so racial minorities or I don't know, social minorities, then in that case, I think that the data minimization principle should prevail, because in that case, or better, as I was saying, we should not process more data just to protect, but once we process data, it's okay to have accurate information. I think that distinguishing between the two forms of vulnerabilities, it's quite relevant, and I think this is a great development of the addition that I made, because actually I was not considering this before, that we should separate the accuracy principle for affect-based and for the processing-based vulnerability. I don't know if this was convincing.
No, thank you very much.
Thank you very much. Now we are very happy to see Frederik, because he was missing, but it's not time for Frederik yet. I think now in this, Alessandra, I think you should see me, and we should see Gianclaudio.
Yes, I am trying to upload you.
Okay. So we are happy to see you, Frederik. You were somehow at the margins of the internet, but now you're here. We see Paul, everybody's here, everything is fine and under control, but it's my time for questions. So please, supervisors, wait a little bit, because it's, I will continue. Yes, so Gianclaudio, congratulations for the thesis. It's my time to answer questions and to congratulate you. You know, I really like the thesis, and I really like the subject, and I really like many things about your work. So data subjects and vulnerability, I really like the question of who are those data subjects, and somebody already mentioned this question of literature gaps. I think there are many gaps, and there is not a lot of people working on who are these data subjects, many articles on who is the data controller, who is the joint controller, who is the processor, but nobody seems to really care about the data subjects, and it's very nice that somebody who is talented in addition does care for data subjects and vulnerability. I'm not sure if I like that much the subject of vulnerability, but I like the fact that you use this notion not indeed to care, to see if it's interesting, but also as a tool to think about data protection law and to think about broader pictures of issues of data protection law. What's the point of data protection law? How does it work? And to really test if the GDPR and the different elements of the GDPR work for something that it's, and how we could perhaps improve this through vulnerability. I like these general issues, and I like the way in which the work has been done, because you have this capacity to master a lot of references, like more the theoretical perspectives. You really have read the GDPR in many ways, and you have read many opinions from DPAs, a lot of case law, and you have also analyzed national developments, which again, it's something that it's to be celebrated and encouraged. So many good things, and still many open questions. There is one question that I don't really have, because so one of the things that you do is that you, in a way, believe in data protection law, so you don't have to convince me that potentially data protection law is a good thing as such, but still, I perhaps I'm still less optimistic than you are, because you already said today, data protection law has these practical tools that can be used also for vulnerability. And I still, sometimes I have faith in general, but sometimes I have these moments of doubt. I suppose even the saints have moments of doubts, but perhaps you can help me having less doubts. And my questions are related to this. My questions are not just questions as such, and I hope one day you will forgive me for this, but I'm not going to ask you theoretical questions. I'm going to share with you a case that it's a real case that I found, and you might not be familiar with this case, so it makes it a bit difficult for you, but I'm sure you will manage. And it's a real case that I found in this register of decisions taken under Article 60 of the European Data Protection Board. I don't know if you have read them, or maybe I found some document that you have not read yet, and I'm quite happy. And just for the audience, in case they want to check it, is a decision that was taken on the 2nd of October of 2019, but I will summarize all the elements for you, so you can tell me. And because I was reading this decision and I thought about you, and I thought maybe Gianclaudio can explain how this relates to this question of who are the data subjects, what is vulnerability. So basically the story is like this: there is a data subject. The data subject, he's a he apparently, this we know, we don't know the name. He's using the internet, he creates an account somewhere, and one day he exercises his right of access through an online template. He does a request for information, and then as a reply, he's told the data controller is not sure that he is him. He has to document that he is him by sending a copy of his ID card. He sends the copy, we don't know the details, or something redacted, we don't know. And when he sends the ID card, the controller sees the date of birth, and they see that he's a minor. Then they say, because you're a minor, you didn't have the right to create an account as a minor. We now deactivate your account. And if you want to use your right of access, you need the parental consent, so the consent of your parents. Send us the ID card of your parents and send us your birth certificate. They say all this. What does the data subject do? He replies, dear data controller, I think you're misinformed. I am actually 15 years old, and in line with Austrian data protection law, he's based in Austria. I have the right to consent. I don't need parental consent. So he refuses to go through the parental consent path. And he says, and by the way, you don't have the right to deactivate my account because I give you this information about my date of birth only for the purposes of identity verification. So this, for me, it's the first part of the question, and this relates to a clear example, I think, of those cases in which some mechanism, data protection mechanism that was apparently there to protect children, the vulnerable, actually is used in a way that is not effective to protect anybody, but it's again useless and an obstacle for this teenager who actually is just a teenager trying to use his right of access, and he's facing all these sort of complications because of a especially vulnerability-aware mechanism of data protection law. Isn't this paradoxical? Isn't this another example of this failure of the GDPR to protect children effectively, and actually, yes, is creating many problems? But that's only like my first question. The second question is that actually, at some point, this thing gets to the DPA, because the teenager tells to the controller, by the way, if you disagree, I can always go to the DPA. Ironical, because actually it should be the data controller who is informing the subject that they can go to the DPA, but he knows. And then he goes to the DPA. It's in Austria. This opens a cross-border kind of situation, and at the end is the data protection authority of Brandenburg who takes the decision through all this mechanism. So many other DPAs are consulted, and they all agree with this decision, which is available online, and which says this little story, it tells the little story, and then it comes to the conclusion that there is nothing wrong with the data controller, everything is fine, not even a reprimand, nothing. And one of the reasons is that actually it was clear from the reaction of the data subject that he was familiar with his rights. And because he was familiar with his rights, the fact that he was given wrong information by the data controller about his rights was not an obstacle to the exercise of his rights, which I thought is really so amazing and a bad thing. So you know your rights. We are supposed to encourage this, that teenagers know their rights. When they know their rights, the DPAs will tell them, you know your rights. Therefore, we lower the standards for the data controllers to give information. For me, this relates to this question of how do we imagine data subject, and could it be possible that if we imagine a data subject that is aware, informed, then we suddenly don't or data protection authorities say, well, you think you're smart, we don't even care for you, we will not even issue a reprimand for this data protection authority. Could you say in practice, imagine I'm an NGO, I'm exercising Article 80 without mandate, can I actually litigate against those DPAs for saying these kind of things, that if the teenager is smart enough to know his rights, it's fine if he's told that he should provide some information that he doesn't even need to provide. What are your thoughts about this? And can we this first question, is treating children as vulnerable actually leading us anywhere? And what do you think about this treating smart data subjects as I don't know, a problem or not needing data protection law? Thank you.
Thank you so much, Professor Gonzalèz Fuster, for this original and practical scenario. I think that practical scenarios are very necessary after a lot of theory. I think that, so I clearly disagree with Data Protection Authority decision, and I think you agree with me. I have a couple of issues. The first is Article 11. Article 11, as I was mentioning before, it's very particular that every reply of mine is very much related to the previous. So Article 11 is clearly referring to the minimization of identifying information just to enable the exercise of rights. So I think that this might be considered an obstacle in principle. Eventually, the data controller could have verified at from the outcome the age of the subject. But once the data controller believes that the age is not enough to be a lawful data processing, this is an unlawful data processing, and we cannot use unlawfulness to put an obstacle to transparency. In my view, if the data processing was unlawful because the data subject because it was against the contract, I imagine that the legal base was contractual base, and the contract said that for minor of certain age you couldn't access. I don't know if this is the case or something else. But even though if it was unlawful, the transparency right should always be there. The transparency right is not conditional to the lawfulness of the principle, otherwise to the lawfulness of the processing. Otherwise, we are in a double problem: unlawfulness experienced by the data subject, but also lack of transparency. But again, I think that another point was very relevant to what you were saying: the age of the children, but the maturity and the smartness of the child. So actually, another nice opinion of the of the Article 29 Working Party, I think was 2018, about child's data protection, etc., was clearly referring that the protection should be proportional to the level of maturity, physical and mental development of the child. And so I think that this proportionality to the level of maturity or to the level of physical or mental development of the child should encourage or recommend or even oblige to a proportional reading of child's related rights. So to a not a strict interpretation of child related rights. We should look in the context at whether, what is the principle for protecting children? In my view, as I was saying in the slide, children can have both processing-based vulnerability and affect-based vulnerability. So they can be less aware or less attentive or less capable to understand privacy policies and exercise consent and exercise rights. And on the other hand, they might be more vulnerable to some effects like manipulation and I don't know, impairment to freedom of speech, etc. So in this case, if the reason to not allow children to access to a certain service is because they are vulnerable under the processing-based scenario, this was totally false, because the child could exercise these rights. So in my view, the level of maturity is in fact proven as enough. While for the affect-based vulnerability, there might be, of course, other issues to analyze, and of course, I don't think that the case takes into account this. So I think that a representative of data subjects might work a lot on this decision. I tried just to look at the bigger picture of data subjects, vulnerable data subject, and how to do a vulnerability-aware implementation of the GDPR. I tried, in particular, in chapter 6, to propose at the end some easier implementation of rights for some data subjects. So, in my view, a clear example is, for example, right to object. Right to object is the corresponding to the withdrawal of consent, where consent is not being the legal basis. So I do the right to object because I want to block the data processing. And vulnerable people might have a lot of problem in exercising this right, because there might be, this is what Article 21 says, there might be a compelling overriding interest of the data controller. But in some cases, this is what Article 21 says, in particular in case of direct marketing, the block of data processing, so the stop of data processing, should be automatic. In my view, direct marketing should be interpreted with an analogy for other cases of vulnerability, because in my view, the rationale was also that direct marketing is a vulnerable situation. It might lead to not every kind of direct marketing. And so in my view, we have some windows to work on existing provisions. Of course, it's not always easy, and that's why, in my view, data protection authorities should also give some guidance on examples, how GDPR should be interpreted in different contexts for different kinds of vulnerable subjects. I hope I replied to your question.
Yes, so you gave a number of elements, but I still think it's a bit confusing, because so the thing that you say about children, it makes sense. So children are vulnerable, but if they know more, you have to recognize this maturity level and treat them proportionally more like adults, like.
Yeah.
That's for children. But then you're saying like all data subjects are somehow vulnerable. But does it then mean that we apply this proportionality principle to all data subjects, and those who know more, we treat them with less pity? And this is something that actually is there in real life. You know, remember this Max Schrems case where some of the parties were saying, you know, Max Schrems, he's a professional of data protection law. You should not treat him like a normal consumer complaining about things, because he knows too many things. But then, of course, if Max Schrems cannot invoke his data protection, if at the moment where you know too much, that you are no longer a data subject that can actually go to the judge and try to have something, it doesn't make sense. So I think I see there a clear risk that we recognize this vulnerability in everybody, but then we start to make this proportionality thing that transforms those who know a bit into knowing too much. Do you see?
Yeah, thank you again for the further development. Yeah, this is a crucial issue, because if we protect more the vulnerable, maybe the average becomes more vulnerable because has fewer protections. Well, I don't think that there should be an erosion of rights of the average. In my view, the average should be always protected, and in my view, the average subject, so the rational subject, if she exists, is already full of. I mean, is already the benchmark for several provisions in the GDPR. So, in my view, we can never use the argument of you as being too smart subject. We should always use the opposite. So vulnerability should be mitigated, but we should imagine a high level for protection for everyone. High risk of data protection, so high risk to fundamental rights and freedoms, relates, of course, to a situation that should be rebalanced. This doesn't mean to create a competitive disadvantage for the average, in my view. I can understand that sometimes this might be used, also in this case, because they say, oh, you're not extremely vulnerable, so come on, you don't need full rights. I think we can never act for subtracting rights from the average. We should just add. Of course, each case should be seen in context. So I don't know if I reacted properly.
Excellent, thank you very much, and thank you for accepting just jumping into a case like this. Really. So this concludes my part of questions, and now we move to Frederik, who had some connecting issues. To put it.
Yes, Paulo, if you can share your screen. Thank you. Let's go live.
Frederik, I hope we can hear you. We hear somebody breathe, but that is
Hello, Fred, here. Do you hear me?
Yes.
We hear you, Paul, but we don't hear Frederik.
No, it was Frederik.
Ah, it was Frederik.
Frederik here. Do you hear me? Over Paul's connection.
Okay, go ahead, please.
Okay. Gianclaudio, congratulations with the beautiful book. Many compliments. I'm impressed how you combine insights from ethics, law and economics, like your original analysis. But now for the question. Imagine that you get budget now to hire 7 postdocs, our whole research team. What type of empirical research would you want them to do? Because parts of your thesis are based on the idea that people can be manipulated and influenced by targeted advertising, etc. But that is largely an empirical question, like how much does advertising influence people, etc. So if you had almost unlimited budget, what type of empirical research would you want to do about vulnerability and manipulation?
Thank you very much, Professor Borgesius, for overcoming technical problems and for this challenging question. Actually, I think that having the possibilities to have an unlimited amount of money to do research on this topic, I think. So I would start from empirical research on average test. There are some empirical research on average consumer. I think we could do some empirical research on average subject to understand what is the percentage of understanding and interest. Of course, there are many. There are already some studies on how much data subjects are prone or eager to exercise their rights or to understand their data protection policies, etc. But I think that if we operationalize what is already the average data subject benchmark that we can see in the GDPR, and then we can test in groups of empirical scenarios. Also, I think that one necessary empirical check is to look at layers of vulnerability and to understand if we can give some clearer examples of layers of vulnerability. So, for example, in my view, the real empirical research is to understand the granularity level of homogeneous small layers of data subjects, to understand if they can act in a similar position, in an homogeneous position. So, for example, it would be very interesting to look at data subject with similar characteristics, employees of the same employer, and suffering for adverse effects from the same employer in data processing, like, I don't know, discrimination in the workplace, to understand their level of vulnerability, etc. You were referring to manipulation, which is even more interesting. So manipulation is, of course, something very, very relevant for an empirical research. So to understand whether, for example, subjects with similar characteristics towards the similar data controllers are the similar victims of the same, I don't know, aggressive commercial ads. This might be extremely interesting. So to look which are the defining criteria, the distinguishing criteria if there are any, between homogeneous groups of data subjects that receive the same online ads, which is aggressive or not. So to see if, and again, to see the effects of manipulation, because this is another issue. How can we know if manipulation was at stake? Consumer law takes an ex post test. If you take an action that you wouldn't have otherwise taken, this is considered a manipulation. This is unfair commercial practice directive. I think that for data protection acts before. Data protection acts before that an effect is taken, that a different action is taken. Manipulation in terms of data protection is already the infringement of the, or actually manipulation in privacy, to be more precise, is the infringement of the private space of the scalp, the private space of the mind. So it's very, very difficult to look at the borderline, I think. But looking at similar effects of similar groups, like a test group without manipulation and another group with manipulation, we can observe and understand more layers. So yeah, I mean, of course, it's not easy to plan it now, but I think these are the main paths of research that I will follow to understand homogeneity of layers, to understand the notion of average and manipulation effects on data subjects. I hope I replied to your question.
Yeah, thank you. I'm happy for now, and seeing the time, I'm happy to give the floor to the next speaker.
We are well on time, and we will give the floor to Paul, and then we will move to the public time if the audience has questions. So if you are in the audience, think about your questions. Then I will give you only a few minutes to ask. Paul, please have the floor.
Yeah, I hope Gianclaudio can hear me.
Yes.
Because I've been playing with so many technologies. I want to ask you a question from the viewpoint of a DPA. A DPA has to enforce data protection law, and they are usually an administration with limited resources and people of normal intellects, and that is good. The state shouldn't be too intelligent, and the DPA neither. But then comes this Gianclaudio arguing that there's a way of interpreting the GDPR that would deliver better results, and that is via the perspective of vulnerability. And this Gianclaudio then proposes a full chapter on how data protection impact assessments could be understood in the light of this value, or in the light of this concern or phenomenon of vulnerability. Am I then wrong to summarize your proposal as follows? In all cases where Article 35 requires an impact assessment, there is a presumption of vulnerability. And if the answer is no, then life will get more complicated for the DPAs, because then they don't have any clue at all when there is vulnerability, or when vulnerability can be presumed. And so how then would you guide them in their very difficult enforcement job? That's the first part of my question. And you can start with it.
So thank you very much, Professor Hert, for this question. I think it's extremely relevant to look at the relationship between DPIA and vulnerability. So starting from the European Data Protection Board opinion on data protection impact assessment, actually was working party opinion. They define 9 index of vulnerabilities, 9 index of high risk. So 9 cases, which is very much arguable, very much disputable, but they needed to give some keys to national data protection authorities and to data controllers. So they enlist 9 cases of high risk. Large scale processing, processing of area open to public, processing of data of vulnerable people, a large amount of data, sensitive data processing, etc. Under this perspective, it seems that processing data of vulnerable people is just one of the 9 different possibilities of high risk. But I tend to disagree with this and explaining why. So actually, the data protection impact assessment opinion of the European Data Protection Board was referring to vulnerable persons under the perspective just of element 1, so data subject characteristics. I referred to data subject characteristics in a slide as just one of the 3 dimensions of vulnerability in the data protection. We need also data controllers, potentialities, and eventually mechanisms used to exploit vulnerability. So in my view, if we consider vulnerability from a labeled perspective, you are vulnerable because you are black, you are vulnerable because you are gay. From this perspective, yes, it might be just one of the 9 index of high risk. But if we take an advanced approach, affirming that actually vulnerability is not just being black, gay, etc., but vulnerability means being in a specific encounter with the data controller that makes me vulnerable to some adverse effects, well, I think that the notion of high risk can well summarize the notion of vulnerability. So I think that the whole data protection impact assessment might be read under the vulnerability lens. It's not just me to encourage this reading, but in another opinion, the European Data Protection Board was encouraging a subject-centered notion of high risk. So always looking at the subject and of course in the context, etc. But from the vulnerability perspective, I think it's important to look at DPIA as the best model. I hope I replied to your question.
Yes, you did, and very interesting way. But so then there might be a danger when we limit the application of the Article 35 scope. We might also limit the potential of the vulnerability consequences. So if we make a strong connection between the 2 notions, then it might have a negative effect, and there are tendencies to limit the number of data protection impact assessments, of course. I don't know, my dear colleague, Mrs. Chairman, or how do you say this? If I can follow up on this?
Yes, you can follow up.
Okay. There is a lot of buzz about group risks and the impossibility for data protection law as an individual rights-centered set of rules to address risks to groups rather than risks to people. And your thesis doesn't take a strong position in that debate. And on the contrary, you seem to and that is the reason why we like your thesis so much, you seem to look for an enhanced application of the data protection set of rules as embodied in the GDPR in a very fresh way. But did you deliberately avoid this discussion? And my question has to do with with your chapter on data subject rights. It is chapter 5, and I've been rereading that chapter, and I think it's not the most strongest one in the whole thesis, if I can say this in public, because it doesn't give us a perspective on the future of these individually organized data subject rights. And although the title suggests that the full chapter is on data subject rights, a closer look reveals that you don't really answer the title, in my opinion, and you speed up your analysis and immediately turn to the principles of data protection. So in the light of all your colleagues, PhD students and others that are working on data subject rights today, a kind of activity that surprises me because I'm quite skeptical about that topic. What is your stand on this? Do you think there's a a new future ahead of us for data subject rights? Could they play a more important role than the smaller role they have played up till today? And linked to that, are you not secretly a believer that the risks are to groups rather than to individuals, and that via vulnerability you want to shift this individual subjective rights set of rules towards a more collective application?
Yes. So thank you again for this further development and for your critical provocations. Yes. So actually, so 2 points: the debate between risk, group and individual risk, and the point on individual rights. So data subject rights. So on the first point, yes, at the beginning, actually at the beginning of the research, as you know, I didn't look deeply into this debate because I thought that a layered approach could solve every issue with a pen, like solving groups, so problems of universalism and problems of particularism with the layered approach of Florencia Luna. Actually, this is still missing a part of the story. That's why after the private defense, I worked at this point of groups, because I think, as I was saying also in the PowerPoint, that we are, if we get a too individualistic case-by-case perspective, we are losing touch with reality. Reality is made of vulnerability issues created by structural problem, and structural problems should be faced also by groups. But groups should never be used as a stigmatization label. So the problem of groups, the problem of being considered part of a social minority, is the problem of self-stigmatization, and so the so-called pathogenic vulnerability. That's why, in my view, group risk, so group-based risks, are important under more contextual scenarios. As I was saying, we should look for homogeneous characteristics, so homogeneous characteristics of the data subject and the data controllers, and in that case we can see homogeneous layers. In my view, it's important to look at groups also from a practical reason, because we need some proxies, some approximation of groups, for example, to exercise data protection rights at a collective level. The representation of data protection right at the representation of data subject at Article 80 might be much more powerful under the perspective of layer of vulnerable people that have a common representative in certain situations. And so I think that the whole story might profit from these homogeneous groups. Also, in the DPIA, the data controller should seek the advice of the data subject. And which data subject? I mean, there should be, even in that case, some form of approximation of layer of vulnerability. So I think that groups are important, but not as a label, but as a contextual layer that should be looked under homogeneous characteristics. For what concerns data subject rights, yes, I mean, in that chapter, that chapter is a hybrid role, both both defining and understanding whether the data subject rights are already looking at vulnerability, and understanding how to implement further them under a vulnerability aware perspective. And of course, the chapter of principles is before, and the subject rights and duties, in my view, needs to be read together and in conjunction. So yes, I think that the subject rights are extremely relevant, and for people that so we should give a reading of data subject rights both aware of the existing letter of the law, that in some kinds of rights there is a strong reference, in my view, to vulnerable people. Article 21 refers to the particular situation of the data subject. And this particular situation, in many member states, at least in 2 member states, has been translated as the high risk of damage, which is our vulnerability notion. Other rights also, like the information rights, Article 12, that is connected to Article 13-15, refers to intelligible rights for children, and so for other vulnerable people, I would add. And so also to have a, vulnerability aware interpretation of right to access. And also right to erasure has a reference to children that, in my view, should be interpreted by analogy with other vulnerable groups. And in particular, to people who are doing research on data subject rights, I would strongly recommend to be very attentive at the group that they are analyzing if they're doing empirical research, because the average group is filled with pitfalls. We don't have an average group of data subjects. So it would be very important to analyze, to have a quite representative group of data subjects to understand what is the exercise of their rights. And also, of course, this is impossible to do in very great detail, but taking into account all possible different situations of imbalances of data subjects might be helpful in making an empirical research in data subject rights. I don't know if I replied to your question.
Yeah, more than enough. Thank you.
Thank you very much.
Thank you very much. Thank you to all members for respecting the time. Now is when this public defense is supposed to be really public. So there is a space where you can type a question if you have a question, and then I can read it. I hope I'm looking at the space, which is the right space, which says Q&A, and I see no questions at the moment, but I will just give a few seconds to see if I see a question. I will already explain what is going to happen next. Next, the members of the jury are going to disappear from here because we're going to deliberate in a separate immaterial space, and we will come back, hopefully all of us, here in probably 15 minutes. So for the members of the public, you should stay there and not leave. There will be some screen that will be shown to you. That looks very interesting. Maybe that's the screen that you will be shown. And then in around 10 minutes, try to see if we are coming back, because we hope to come back and give you the conclusion of this assessment. I don't see a question. I hope I'm really looking at the right place. I don't see anybody telling me I'm looking at the wrong place. So I will just assume there are no questions from the public. This is recorded. I give you the floor, and there were no questions. I hope society at large will have the opportunity to keep discussing with Gianclaudio in the future. So Gianclaudio, I think you have to somehow be around also, but you can probably not. You don't need to have yours be just connected there, and you can breathe a little bit. So I think we can conclude this part of the deliberation of the defense. We disappear, members of the jury, but don't go home or stay home, but connect in the other private space. And we come back here in around 10-15 minutes. Thank you. See you in a little while. Okay, so I see most of us are here. I start talking in case somebody needs to be warned. But I see we are all here. Alessandra, maybe, okay, we are all here and we are all present, and I hope we are live. We're almost all here. Frederik is with us in a strange construction, but we will see him somehow. As the chairperson of this, I'm supposed to give the information to Gianclaudio, but as I mentioned, I have actually the honor to give the floor to Professor Gutwirth, who will communicate you, dear Gianclaudio, the conclusion of our deliberation. Serge, we need to see you, ideally. Suspense.
Serge, you are muted.
You're muted and without camera.
I'm muted, but I'm visible.
Not visible.
Yeah, we
yes,
see.
he is visible.
Yeah. Good.
Yes.
Please have the floor.
Okay. Gianclaudio, I have the honor to do the administrative and official communication in this, so I will try to look very serious. This has to happen in Dutch, so there we go. Wij, voorzitter, secretaris en leden van de commissie Recht en Criminologie van de Vrije Universiteit Brussel, belast met het afnemen van het examen van doctor in de rechten. Aangezien de heer Gianclaudio Malgieri, geboren te Acerra, Italië, op 24 augustus 1992, in het bezit is van een universitair diploma laurea magistrale in jurisprudenza, LLM Masters of Law aan de Universiteit van Pisa in 2016 en een licenza magistrale aan de Sant'Anna School of Advanced Studies in Pisa in 2017. Aangezien de heer Gianclaudio Malgieri een oorspronkelijk proefschrift heeft ingediend getiteld Data Subjects in the GDPR and the Protection of Vulnerable Individuals, aangezien dit werk door de commissie werd goedgekeurd, aangezien het door de examinandus in een openbare zitting werd verdedigd op 31 augustus 2020, aangezien alle decretale en reglementaire voorschriften werden nageleefd, verlenen wij, this is the important moment, aan de heer Gianclaudio Malgieri de graad van dokter in de rechten. And now normally there should be a lot of applause and flowers should be given to Gianclaudio. So yes.
Confetti, confetti. Okay. So congratulations, Gianclaudio, in the name of the jury. We were all happy with your work. I hope you got this message, and we will be happy to follow your work in the future. Then we are sure we'll keep even improving if possible. So yes, congratulations. I hope you got the core of the message. It's very positive. And now we try to do this everything in not to take too much time of the audience, but I will give the floor to your supervisors and actually to Frederik, who will say just a few words to you. Frederik, we can see you. That's a positive thing, and we can maybe hear you.
Hi, can you hear me?
Yes.
Okay. Dr. Malgieri, congratulations. It is an honor to have worked with you, and I congratulate you again on your beautiful thesis. And I want to make a few remarks about the beautiful time that Professor Paul de Hert, Paul and you had the past couple of years, where we had the honor of helping you finishing this book. What perhaps not everybody knows is that next to writing a PhD thesis, which is quite a feat in itself, you also published an insane number of impressive papers in international peer-reviewed journals. You also published more than 15 book chapters, edited 2 books. I'm actually rather worried. Do you get any sleep at all, my poor guy? And we've also spoken at various conferences together in the United States, for instance. You've spoken for the US Senate, for the Federal Trade Commission. It is, I worry about your sleep. But you succeeded in finishing all that. On top of that, you succeeded in writing a very impressive PhD thesis. And you did all that in a good mood as well. It was really fun working with you, because I remember from my PhD writing years that it is fun, but it is also heavy, because, for instance, when you gave us a chapter, then we gave you one compliment, like, yeah, it looks good, but now we're going to tell you how to do it better. And then you have to sit through 2 or 3 hours of criticism. And I remember that is quite demanding, but you always took that in a good mood. You were always open for criticism, eager to learn, and indeed the next version of the chapter was improved. So thank you for the fun years, and congratulations not only with your doctorate, but also with your new job in Lille, which is good news for us, because that means that you are moving to the north of Europe. So when we can all travel again, then it's easier for us to meet up in Belgium and France and the Netherlands, etc. So 2 times congratulations. First with your doctorate, second with your new job. And thank you for all the fun times. Yeah, that's it. I'm looking forward to more cooperation in the future.
Thank you very much, Frederik. Before I give you the floor, Gianclaudio, I think Giovanni wanted perhaps to say something. Giovanni?
No, it's okay, Gloria. I just wanted to thank, since I know, since Gianclaudio was 19, has been following his unfolding in the academic life until today and tomorrow, in which he will be formally be a colleague of us. I'm proud of what he achieved, and just wanted to stress from my external point of view how important you all and other people, all members of committees and other people have been in helping Gianclaudio reaching this result. And as Gianclaudio knows, as our tradition, since now he is a doctorate student, we will switch from what is in Italian lei to il tu. So we will be calling each other by name, not anymore by titles or surnames. So that's an achievement. But I wanted just to congratulate Gianclaudio for this journey, and I enjoyed this 8 years. And thank you all for the inputs you gave this little son abroad, academic son abroad.
Thank you very much. It is a bit difficult, of course, for us. It's a bit cold situation, like to have this proclamation online. But I hope, Gianclaudio, that you get a warm feeling also from the audience. If you want to say something, it's now your opportunity. Yes, you want to say something?
Well, I cannot be more happy. I mean, I am extremely grateful to everyone, to the people that expressed these nice words before me. But I wanted to say that the 31st of August is a particular date for me, because I started my my PhD job on the 1st of September, and now it's exactly the completion of 4 years. And tomorrow it's a new season, because my new contract starts exactly tomorrow. So this coincidence of date is amazing. I wanted to thank you to everyone, in particular to my families, my family in Campania, my family in Pisa, and my family in Brussels. I wanted to say thank you to Professor Paul Hert, because he was helping me in this difficult Brussels years and putting me in more and more new challenges that I hope I get at best, but much better can be done in the future. From an email of 2016, everything started. Frederik, Borgesius, for his great generosity and incredible help. Professor Giovanni Comandé, or just Giovanni maybe now, because when I think of a father, I think of his face, in particular intellectual father. I wanted to say thank you to all other members of the jury, because it's not, I mean, I'm extremely proud to have all them, and I've chosen them because they were relevant in my path. Orla, Lynskey, Joris van Hoboken, Professor Gutwirth, and of course Gloria. You all members of the jury were extremely relevant in my path so far, and I am extremely appreciated all this. And last thank you, I mean not last, other two, one to LSTS group, and in general Meta Juridica faculty, all friends that I had there that helped me, and in particular the group of active revisor and reviewers of my thesis in the last week of May. They really helped me in such a short time. I cannot name all, maybe just their name. I mean, maybe it's not the case, but I was so full of gratitude, and maybe I don't deserve such a great amount of love and intellectual stimuli, and my Pisa family too. So in addition to my Brussels family, my intellectual academic family in Pisa, and my new family in Lille. I hope that these three cities that are not on the same line, but very, I mean, from north to south, I think that I will spend the same amount of time in at least these three places, for sure, getting the best of everything that I can. I'm a bit emotional now, so I cannot exactly say everything that I wanted to say. Just thank you to everyone.
Thank you very much, and we applaud. If you are starting your new job tomorrow, I think you only have a few hours to party and to celebrate. So please go ahead in a safe way, of course, respect all the rules, but enjoy those moments. So congratulations. I think we can conclude here. Thank you to all the members of the jury for the time. Thank you for the audience for being there. And again, congratulations, Gianclaudio, and see you soon, probably. Yes.
Thank you.
Bye bye. Yes, we needed some special effects. Now Alessandra should put here like football, like the football without audience.